Thank you. Please be seated.
We're on the record, Your Honor.
Thank you. We're on the record in cause number 26-1-10235-32. This is the matter of Aaron Farinacci. This is a time and date set for an arraignment. An arraignment is a preliminary appearance where an individual is asked to make a preliminary plea. Typically, an individual enters a not guilty plea at this time. It preserves the right to trial. At this time, the court has several motions to address. First, though, Mr. Farinacci, would you state your name for the record?
Aaron Forrest Farinacci, 1989.
Mr. Farinacci, you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to represent you. Do you have any question about those rights that Mr. Charbonneau can answer for you?
I do not.
Very good. Mr. Charbonneau, being appointed here to represent you, you have the right to a speedy and public trial in the county where the offense is alleged to have been committed. You have the right at trial to remain silent. You need not testify against yourself. You have the right at trial to testify and have witnesses testify at no expense to you. You have the right to hear and question witnesses who testify against you. You are presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Any questions about those rights for your attorney?
No.
Very good. At this time, the first matter we have is a request to shorten time to amend the information. Is there any objection to hearing the motion to amend on shortened time, Mr. Charbonneau?
No, Your Honor.
Court will grant that request. Any objection to probable cause at this time as to the amended information, Mr. Charbonneau?
Judge, we're going to continue to reserve any argument with respect to probable cause.
Thank you. Prosecutor McCollum, any additional argument as to the amendment at this time?
No, Your Honor. The state's prepared to ask the court to enter amended release conditions in relation to the amended information.
Thank you. The court will first, having reviewed the amended probable cause affidavit, do find probable cause for the amended charges. In finding probable cause at this time, we will turn to granting the motion in order amending the information. We will turn to argument as to release conditions. Mr. McCollum.
Your Honor, I'm asking the court to impose the previous release conditions with the addition that I am asking the court to increase bail or bond in this amount to $2 million given the gravity of these charges, given the addition of 4 separate arson counts. I am asking the court to increase that bond at this point and include the previous conditions, which included appearing at all court dates, regular contact with counsel, remain in Spokane County, commit no further law violations, obey any and all orders in effect. Likewise, no approaching or communicating with any crime victims or witnesses as outlined in the probable cause affidavit, and then no frequenting of any of the areas or known locations listed in the probable cause affidavit for the offenses charged. Likewise, to have no use or possession of any lighter, matches, torch, or any other fire-starting device.
Mr. Charbonneau, any argument as to bond or release?
No, Your Honor, we're going to continue to reserve argument with respect to bond and release.
Thank you. Based on the arguments of Prosecutor McCollum as well as a review of CR 3.2, the court does find that there is a significant risk to community safety as well as the potential for a violent offense and future failure to appear. The court believes that the amount as requested by Prosecutor McCollum is appropriate and will set bond in the amount of $2 million. The court will adopt all other release conditions as proposed at this time and note the reservation on those by defense. Turning then to the amended information. Mr. Charbonneau, have you reviewed the amended information with your client?
Judge, we have reviewed the information, but we're going to move the court for an order for competency evaluation pursuant to RCW 1077. I provided those documents to Mr. McCollum and the state. They have signed off on those documents. So procedurally, Judge, I don't know if the court would like to invoke the 24-hour rule, but we anticipate that hearing being struck as soon as we enter the appeals court.
Mr. McCollum, what's the position of the state?
Your Honor, the state's position is in light of the defense motion on the 1077 that precedes the arraignment given the nature of the request from defense. So I believe at this stage procedurally that would stay arraignment in light of the 1077 request at this time.
The court will consider then this matter stay. The court will review and anticipate signing off on the presented document to have the evaluation conducted. I don't believe it would make sense then to set another hearing within the 24 hours, though if that order is not assigned and stayed, the court will reset arraignment within the 24-hour period pursuant to the rules. So at this time, the court will review documents associated with the evaluation. With that, Mr. Charbonneau?
Judge, we'll have those documents to you this afternoon.
All right. And Prosecutor McCollum, anything additional?
Your Honor, in terms of if the court does grant the 1077 stay order and evaluation, and then we would need a scheduling order placing this on the stay docket. Mr. Charbonneau has prepared a scheduling order with a proposed date of September 4th, 2026 on the stay calendar. And so that, my understanding, will be presented contemporaneous with the order on 1077.
Very good. The court will review that. In addition to reviewing the stay order, the court will review the scheduling order and set appropriately. If for any reason that the stay is not granted, then this matter will be reset for tomorrow, though the court anticipates that it will review and sign off on the scheduling order pursuant to the pleadings. With that, that will conclude this matter at this time. Mr. Farinacci, you will remain held on $2,000 bond, as well as the other conditions of this court. $2 million bond, in addition to the other conditions of this court as indicated herein. That will conclude this matter. The court will step off as we transition to our next matters.
Thank you, Your Honor.
Thank you, Your Honor.
We're off deck, Your Honor.
All rise. Thank you. Court is now in recess.